I'm going to start again. Good morning, everybody. We are delighted to have all of you here. I'm sorry for that brief technical difficulty with our film that we normally start with. But we have a terrific panel this morning on whether arbitration is proceeding as normal or is everything changed? Is there a new dawn? And new dawn is especially appropriate to me since I'm sitting here in San Francisco where it is morning and the sun is rising. And I know we have participants from all over the world and a wonderful panel from New York and Rome and Italy and Paris. As you all know, the UIA has been very active these past few months during this strange period of COVID. We have had scores of webinars, we have podcasts, we have videos, we have sites online, we have an exchange on LinkedIn, we have document repositories. We have been very active. We have been addressing issues related to COVID. We've also been addressing issues related to the rule of law. We had a wonderful panel about that on Friday. I want to thank all of our members who have been so dedicated and so active in keeping the UIA vibrant during this time. And in fact, it's exactly during this time that an organization like ours can play such an important role in keeping all the lawyers of the world involved with one another and connected to the legal community. And with that, I want to turn over the floor. I'm going to shut off my microphone and my video, turn the floor over to one of our two moderators this morning, Florence, who is in Paris, who will be moderating with Andrea CARLEVARIS, who's in Rome. And I wish you all a wonderful seminar on this important topic. Thank you very much.
Thank you, Jerry, for this kind introduction. As the chair of the Arbitration Committee, Commission of the UIA, I'm very pleased to welcome you as attendees and my colleagues as panelists. We are very lucky to discuss our topic of today with colleagues, legal lawyers, with representatives of arbitration institution and with in-house counsel. I draw the attention of the attendees that you can put questions on the little system you have on your screen, and we will try to get replies to you questions. I put now the floor to Andrea, who will moderate the panel. Thank you.
Thank you very much, Florence, and welcome both to our speakers and to all the participants who are, I understand, quite numerous. This is certainly not the first seminar that is being organized on the impact of the pandemic on international arbitration, and certainly it will not be the last one. Unlike other similar seminars, however, what we are really interested in discussing today is the future, is the long-term impact of the current circumstances on the way we do international arbitration. In other terms, what the practices and habits we are being forced to take on in these extraordinary times we are living will have as an effect in the long run, in the years to come. Speaking to colleagues over the last couple of months, I noticed that there is quite a clear divide between those who can't wait to go back to doing things as they were used to, including traveling extensively and attending hearings and conferences, and those, on the other hand, who, along with, of course, the problems and concerns of this time, also see an opportunity for change in what we are experiencing. Now, given the nature of this debate, we thought it would be interesting to invite representatives of different categories of stakeholders: counsel, in-house counsel, and arbitral institutions. And we are, of course, very curious to see whether their visions for the future are aligned. This is going to be a very informal conversation. As Laurent said, participants may ask questions on the dedicated chat, and time permitting, we will make sure that the speakers will be given an opportunity to respond. Now, let's start perhaps with Mike, and precisely with the more general question. We will deal then with some more specific aspects. And the general question is, do you think the current emergency will have long-term effects on the organization and conduct of arbitration proceedings, or will this just have been a relatively long break after which we will all go back to doing things as we've always done, precisely with extensive traveling, long hearings, etc.? Mike.
Yeah, thanks, Andrew. Andrea, Andrew and Andrea. It's a great question, and I hope that we don't return to doing things as we were, and honestly, I don't think that we will. You know, law is, you know, like in a sense, like science, it's a cumulative profession. We accumulate things, we aggregate the knowledge that we have acquired from the past, and we move forward with the innovations. We tend to be a conservative profession where it is hard to innovate through dispute resolution, but we're being forced to innovate right now. And an interesting thing, Andrea, I think it's actually, you know, maybe worth actually talking a little bit about the relationship that you and I have had over the many years. I'm based in Florence. I'm a New York trained lawyer. And when I started here in 1999 at the company where I am, the Novo Opinione, which is part of a company called Baker Hughes, for many years part of General Electric, you were the case manager at the ICC that I was most in contact with. And you and I have had many conversations over the years, often from my frustration with arbitration in 1999. I were calling you and we'd catch each other late at the office. And sometimes they were heated discussions about what could be done and what couldn't be done with arbitration. And both of us, I think, have evolved in our views over the years, probably influenced very much by what we've learned from each other. I mean, I think that, you know, we have already seen changes that are taking place in our own world. I'm now in the office today, but I haven't been in the office for the last 2 or 3 weeks. I may not come in for another couple of weeks. Why? Well, because my company is saying, if you can work from home, continue to work from home. And we're all now getting accustomed to doing things that, and I had an outside counsel that I was speaking with just last week who said everybody was afraid of letting the associates and the junior lawyers work from home because they thought nothing would get done. Now they find, in fact, that a lot more work is getting done, that work is actually more productive. So I think, I do think that we are facing a situation where innovation is being forced upon us. And my hope is that we will not, while a lot of the focus is this discussion is how do we do things online? I think that because the online technology today, fortunately, I say fortunately, because the online technology is not perfect. Because of the imperfections of the technology, we have a perfect moment to introduce innovations, to do things that we probably should have been doing years ago, and that some people were doing, but now more are embracing. And I know Ziva is going to speak about the ICC note on mitigating the effects of COVID, but I can tell you in all of the recent arbitrations that I've been involved in, whether they've been ICC arbitrations or arbitrations with other institutions, Article 8 of the ICC note, which talks about case management techniques, that are ways of avoiding the need for a hearing or substantially reducing the need for a hearing, I found to be a touchstone for us in order to maintain the forward progress of our arbitrations and get things done. And I find that there's been an openness to looking at those techniques that are proposed at Article 8, and people are now thinking of other things that might be done. I was speaking the other day with someone that many of you may also, Mohammed Abdel Wahab, who's a prominent Egyptian arbitrator, who had the idea, and I have to give him full citation, this was one of these ideas that came to him. He said, why don't we now, since we're all convening online and we don't have to get together physically, why don't tribunals talk to parties or have a quick catch up after the exchange of submissions? And I thought as a party, well, why not? You know, I think that might actually render the process for us more predictable. It might make it also give us a sense that the tribunal is actually engaged and give us a better direction of which way we would want to go. So I think that we're really, you know, I don't want to speak a long time, but I really think this is a moment to, it would be a pity if we just try to take all of our current practices and move them online instead of taking this as an opportunity to really adapt and change so that when hopefully these things subside and we're back to what a more or less normal life, we'll continue to be much better at what we do in resolving disputes.
Ziva, Andrew, any comment on this general picture?
Harking back on a few things that Mike said, I think in particular about the legal profession being fairly conservative and sort of reticent to change. I think one thing that's certainly happened here is that we've had the opportunity in a number of different contexts to try out new technologies, and I think that's opened up, the options for various different approaches. And one thing I think for sure is that we've all been forced to become more fluent and more capable in using these technologies. And so I think in the case where you have disparate parties and not that much in dispute, holding isolated hearings on issues like jurisdiction or security virtually, I think is one way that certainly proceedings can become more efficient. And I think people are becoming more comfortable with that option. Case management conferences. I think we'll talk about in a little bit whether or not the full-blown evidentiary hearing in the cases that really require it would be replaced in all cases virtually. I'm not sure, because I think there are benefits to being in the same room and being able to make a personal connection with the tribunal from the sense of advocates, and also have the tribunal having the opportunity to get a personal impression of the witnesses in cases where witness testimony is really important. But I think certainly there are cases where live witness testimony is not critical to the sound resolution of the case. And I think some of the new technologies that we're dealing with now really provide some opportunities for being innovative in how we resolve those cases in a more cost-effective manner and timelier manner. So I think it's certainly going to usher in some change.
We'll come to hearings in a moment, but yes, I would be interested in knowing whether the ICC is preparing for some sort of permanent change, both in the way it works internally and in the way it interacts with parties and arbitrators and cases.
Definitely, and I just maybe just a step back. I completely agree with what Andrea and Mike have said, and in fact, I think that we cannot unlearn what we learned now. This has really forced people to forego what is things that they're used to and accustomed to, and things that they feel more comfortable with, for the benefit of things that actually prevent huge delays now. And I think this is the kind of the discussion that we cannot undo. We have seen what is possible, in the presence of very strong objections, tribunals reasoning very clearly why the hearing will go forward in a virtual setting in the appropriate circumstances, and reasoning away all the strong arguments, strong objections that one party may have had. And we have now seen those discussions. Some are done very, very, very well. And I think that, with all this pressure on reducing time and costs, I think that the institutions especially will have a very strong role of reminding arbitrators and parties for years to come of, well, we have seen that work before, and you have to make the procedure proportionate to what is at stake, and so on and so forth, and try to keep the costs and the time down. So I definitely think that this is the state of affair, the state and the operating mode that we had for 2 months now is not going to just continue indefinitely, but we're not going to go back to where we were in January this year. And now on your question, Andrea, on the it's quite a layered question. One thing is whether we have any plans for offering a virtual hearings platform, and that is something that we will discuss later on. But we have now introduced a different way of operating during this time. Everything is by email. For the time being, it's by email, and many of you will know that we are now in the final stages of actually offering a new platform for case management in our cases, and part of that platform will also be a SharePoint facility for a safe and secure sharing of documents. This is something that luckily we have begun way before the crisis, and I must say that this sanitary crisis has worked in our favor because our providers have had more time to dedicate to us. So we are now really almost there. And we are also focusing on the hearings, but maybe I come to that a bit later, or maybe not.
Yeah, I think it's time to talk about the hearing, because obviously, given the current prohibition, still in I think most of the world of large meetings, the most affected phase in the arbitral proceedings is of course the organization of hearings. And as the ICC guidance note suggests, I think that the current situation may have two types of effects on hearings. First, by, in a way, avoiding hearing altogether when they're not necessary, or limiting them to really relevant issues. And second, when a hearing has to be held, doing so virtually. Now, the ICC, just to take an example, provided a tribunal can decide on the first issue whether a hearing should be held at all. Tribunals can decide not to hold a hearing and to decide a case on documents unless at least one of the parties requests a hearing. But it is also quite clear that arbitral tribunals enjoy broad discretion and freedom in decide how to organize the proceedings. And I was wondering whether in a time like the present one, these rules could not be interpreted in a way to empower tribunals to take a broader approach to their powers in terms of organizing or rather not organizing hearings. So, for example, could arbitrators refuse in the future holding a hearing even if one party so requests? I was wondering, Ziva, whether you already had these kind of problems or experiences in this respect.
Yeah, I think that, you know, a very useful point of departure for this discussion is our experience in the expedited cases. Expedited procedure is the procedure that was introduced for cases up to 2 million at the moment. In 2017, and in those procedures, because they are smaller claims and less complicated cases, the tribunal has the power not to hold a hearing. That's the main difference. Interestingly enough, that is not the most commonly sacrificed feature of a normal procedure, if you will. I have just checked the numbers, and you know, hearings were held in 36 of the cases where we have finished, and 22 didn't have hearings. If we compare that to, you know, document production, only 23 cases had document production, and in 35 cases the parties didn't want to have document production, and the same numbers go for post-hearing briefs. And I think that so in many cases parties actually agree to have a hearing, and the tribunal also, and I have had the chance to discuss with a few tribunals, the tribunal also quite gladly agrees to that, and not only because of the due process paranoia and because of any fear in that regard, but also because many people find that actually holding a hearing, short hearing by video conference, where appropriate, is actually more efficient for the case. It allows you to streamline the discussion, and you don't have to have another round of submissions. So, and there is, of course, also the right to be heard argument that is important always, of course. And I think that for both of those reasons, the way I see this going is rather than the rules changing in the sense that there will be no more hearing required, even, you know, that the tribunal can decide not to hold a hearing even when one of the parties wants it. I think what will change quite a lot is that the lessons learned during this period will lead to a much more serious appreciation of whether a virtual hearing is enough or whether a hearing in person is actually necessary. So, and in the guidance note, there is also in the handouts there is quite a useful list of all the elements that the parties and the tribunal should consider together. And that is, of course, the nature of and the length of the hearing, the complexity of the case, any particular reasons, any particular hurry in the case, and how much delay the rescheduling will actually entail. And importantly, and this is something that we've seen sometimes tribunals not fully appreciating, is the need, really assessing the need for the parties to properly present and prepare for the hearing. And that's a technical issue, that's a practical issue. And of course, also assess whether what are the chances that this will pose any risk to the enforceability of the award. And something that has worked quite well since we issued this note is the parties actually receiving reasons for the decision whether or not to hold a hearing virtually. Although one party says that its proper right to be heard will only be ensured if the hearing is held in a physical form. I think that, however, there is, and this is also in the note, there are several other ways that the tribunal can ensure that the parties have the right to be heard, and those ways are listed in the famous paragraph 8 of the note that Mike has already mentioned, and it all comes down to the tribunal having a proactive approach to discussing these issues with the parties, to getting out of that box of we have one case management conference and then off you go, then you're in the hands of the tribunal, and then whatever happens in the middle of the case, we have to stick to that. There is a lot to be gained from a further meeting with the parties and discussing with the parties all the issues, whether some issues could be taken out and decided, issues of fact, issues of law, whether the experts can work with the tribunal, whether you could have many different options that are available and that are listed in that article. So I think that so I don't think that the rules will necessarily change in that regard. I think that many institutions will probably be reluctant. What I think has become clear now to some dissatisfaction of some people who have raised objections is that holding virtual hearings is something that is available to the tribunal. Decide to hold virtual hearings is something that the tribunal can decide under its discretion, procedural discretion. And this is something that in fact we're considering clarifying explicitly in the next edition of the rules, so that like you have now for expedited provisions, that the tribunal can hold the hearing by video conference or telephone call. We will also have that for explicitly black on white for the avoidance of any doubt, also in normal proceeding.
I think we tend to equate the right to be heard with the right to a hearing, if not to an in-person hearing. And this is probably the right time to start thinking whether this equation is indeed valid. Yeah. Andrew,
I agree, Andrea.
Yeah.
Could I
Mike,
just jump in and say that sure. I think that there, from a party perspective, I would say that we would expect, and we have you as the former Secretary General and Ziva, who both are representing the ICC. So, but not to pick on or promote either way the ICC, but maybe to use this as an example. You have in the ICC rules under Article 25 or Rule 25, where it basically says that the parties. This goes to the issue. It says the parties. The arbitral tribunal shall hear the parties together in person if any of them so requests, right? And maybe this is something that I think you may find analogs to this in other institution rules, and it may be useful for the institutions to do two things. First, perhaps clarify that when they say to be heard in person, that in person can also mean virtually, that you can do it online. It doesn't mean physically in person. I think that's something institutions can provide guidance as to what their rules say. But then I think it's also incumbent upon parties in counsel to verify that the law of the seat and laws at the place of enforcement, but particularly the law at the seat of the arbitration, are not going to raise any issues that, even with the institution interpreting its own rules. My experience, if the institution comes out and says our rules mean this, then likely, courts at the seat will defer to how the institutions suggest their rules should be interpreted. That's one thing. The other thing I think would be useful for institutions to do would be to amend their rules to address these situations. Perhaps, to your point, to focus on the concept of the right to be heard as opposed to the right to a hearing, and perhaps not give the parties this unilateral right, as the ICC rules appear to insist upon a hearing with the other side present if the tribunal determines that it's not warranted, that you can actually make sure that the case is fully vetted and is heard without a so-called hearing taking place.
Andrea, we've seen that Chaffetz, Lindsey, you recently published an interesting and very practical report from a recent experience you had in a case where, after the first of 2 weeks of hearing, at the end of fact witness examination, when you had to start with expert witness examination, lockdown intervenes and you are forced to continue with a different modality that you managed to organize in a very short time frame. So if a hearing is to be held, which I think is still the case, at least in larger cases, do your experiences like yours might teach us something for the future? Or if I can take it even further, as technology progresses, as budgets get tighter and protocols are being adopted in several fora on the conduct of virtual hearing, is it realistic to assume that virtual hearings may become the norm in the foreseeable future?
Sure. I think in some cases they may. I think in some cases you might see sort of a mixed approach where certain parts of the proceeding would be virtual, others might benefit from a in-person hearing. I think one of the best advantages of arbitration is that I think it allows for, in many cases, a bespoke sort of approach to individual disputes, and the parties obviously have autonomy to define how they'll proceed in their agreements. I think, I doubt people have agreements in place now that address this issue, but I do think, our experience was that if you have a tribunal and you have opposing counsel who are dedicated to resolving the dispute as efficiently as the clients want, and with the best means available, then you can get things done. And we didn't really find that we didn't find the virtual platform to be much of a handicap, but I do think we had the advantage of having had a week's worth of in-person hearings, and we had prior proceedings in the case, including case management conferences, jurisdictional objections, where we've had the opportunity to be in the room with the tribunal. And I do think that still remains an important part of the process, and it's something for parties to consider. But I think on a whole, our experience was certainly that if the parties wished to proceed virtually, and I think that might be the case, particularly when there's time concerns and cost concerns, which we've talked about, it is a viable option, and that the technology is there now to allow to really simulate the in-person experience as best as you could hope for, I think. And I think that technology will only improve, and I think people will only become more comfortable with that. So I guess just the short answer is I don't think it's a one-size-fits-all. We'll see a wholesale move to virtual hearings. I think there are certain situations where, especially very fact-intensive cases that depend a lot on witness credibility, where in-person hearings in the traditional sense are very much worthwhile, and I think important to the resolution of particular cases. But I think that's not the case in all instances. And I think now, having gone through this experience, and I think as more and more people become comfortable with the virtual alternative, I think the traditional sense that you have to hold an in-person hearing, and live in-person hearing in order to satisfy due process concerns, I think that may very well and should, I think, fall by the wayside.
And I think, as your article suggests, it may be easier with experts than with fact witnesses. I mean, experts is probably an examination that is more based on a presentation, followed, of course, by questions and cross-examination. But with fact witnesses, it may be more difficult, or rather, the demeanor, for example, is maybe more important to the outcome, the effectiveness of the examination.
Certainly, and I, one issue we had was all of the fact witnesses were testifying in Portuguese, and the proceeding was in English. Now, I understand that the technology is available to make simultaneous translation in a virtual hearing as effective as it is in person. That's what the translation services tell us. I hadn't had that experience, and I've had a number of experiences with virtual hearings of different ilk before, including some smaller evidentiary issues. I've never dealt with the issue of simultaneous translation virtually, so I can't speak from experience as to whether or not that is as smooth as in person. And I think the other thing is, as you mentioned, given the fact that I think expert testimony is more lends itself more to virtual hearing perhaps than fact witness testimony. And I think one alternative, of course, is to plan to have the portions of the hearing that will most benefit from live in-person proceedings proceed that way, and then if it's cost effective and it's time effective to move to a virtual hearing for the balance. I think the technology is there, and I think people are becoming more comfortable with the platforms, and so that might be a viable option.
Ziva, the ICC note refers in this respect to suggested clauses that are proposed to parties for adoption as protocols for virtual hearings, a checklist in this respect, and also, of course, there is a compilation of tools that are already available. Is the ICC also considering going a step further and possibly, you mentioned also recent developments in terms of an online case management tool. Is it conceivable that the ICC will also offer actual services in terms of holding virtual hearings?
It is very conceivable. Yes, we are. We have a team working on this since a while now, and we had some hearings, very little hearings, a lot of discussions, a lot of questions answered and support offered, but only a handful of hearings that our hearing center actually helped to organize and set up. Those were, I think there is a couple of case management conference and a hearing that was held in April, a one-day hearing, so quite a simple hearing, you see. And our dedicated team from the hearing center has actually helped them to, provided online training, ensured that in advance that they know how there were no connectivity issues, that they knew how to connect and so on. And then they were also there to in case that somebody would get disconnected and so on. But there wasn't any moderation from the ICC. What we are now looking into is going a few steps further, not only one step further, and actually offering a package, a service, a proper service, and it's on two parallel grounds. One will be using the Microsoft Teams system, which the ICC has started using already before this COVID crisis. So it's something that we have, and we can organize a hearing, but we all know that Microsoft Teams at the moment is still quite limited in functions. In features, it doesn't have as many features as, for example, Zoom. So we will also offer a solution based on Zoom. What we had to do, and it actually follows from Andrew very helpfully, some elements to consider that Andrew very helpfully pointed out, and that is, transcription services, translation, and so on. If we offer a solution, we wanted to be absolutely sure that this is up to the level of the service that the hearing center has been offering for years in physical hearings. So, you know, you have to ensure that there are plugins, that the translations work, that, and so on and so forth. And Zoom also had a security issue, we may all remember, and our IT team has now, you know, verified that that's actually to a satisfactory level. Zoom has changed some things, quite a few things, so that's now going to operate. So basically, what we will have in the short term is, you know, an option for the parties to choose a system where there will be a team at the ICC, one moderator that will also, you know, be moderating the call in terms of muting people, unmuting them, and so on, and also technical support for if there are technical issues there, and the rest we will continue as we are doing already now. So probably it may also be helpful for everybody to know that if you have issues, if you have questions, parties and tribunals, you can contact the ICC, and as we have done in many cases before, you know, we can, you know, there will be, you know, the team will check that, you know, everybody can connect, that a system that works for everybody is chosen, is put in place, that everybody can connect, that everybody is trained, so to say, enough to be able to use the system and to be comfortable with the system. So exciting times ahead. I think that what I wanted to say in response to Andrew's, you know, crystal ball gazing is what we think will happen. Hybrid hearings in a lot of, at least I'm looking at the hearings that, you know, at the type of cases that usually hold hearings in the hearing center. It's usually the more complex, bigger cases. And in those cases, it may be very, very difficult for everybody to be connected. But what I think we will see more is that a certain expert will be in another location and will be dialed into the hearing by video, or the tribunal will be in one location, the counsel with their client in another location, and so on. And a lot of different combinations of things that work. Also according to, you know, where everybody is and what their technical capabilities are. I mean, I have just been told so many times on this call that my connection is weak and I may get thrown out. So, and I'm in the suburbs of Paris. So I think that this is the future in terms of hearings. I think we'll see a lot more, many more combinations, and hopefully, I really sincerely hope that also combinations of issues that go to the hearing and issues that do not go to the hearing. You know, that there are a lot of issues. We have these hearings where, you know, like everybody's completely lost, with the tribunal not being properly able to follow the experts' references and so on. Potentially, that would be much better solved by written exchanges between the tribunal and the expert, and a host of other different solutions that maybe. I think that what we will see is really a very complex, you know, very many different combinations of how to most efficiently resolve and in the fastest way and effectively solve the disputes.
Hey, Andrea, could I just make a comment on this? And I may refer back, and I don't remember if you know this conversation we had well over a dozen years ago, and it may have been even before you were Secretary General, went on to become the Secretary General of the ICC for a period. And we were talking about, I think my complaint at the time, this actually may have been while you were Secretary General of the ICC, because I might have been complaining about some cases. And, you know, we were talking about process and how, you know, your point of view at the time to me, and I think I've come around more to your point of view on this, which is that, you know, the job of an in-house lawyer sometimes is to explain to the client that legal process takes time, right? I don't know if you remember saying this, but you said, you know, your job is, you know, you need to make sure that your clients, that the CEOs understand that if you want fairness, that due process is something that, you know, the parties have a right to be heard, and you can't just do this overnight, otherwise you're just flipping coins. And I think my response to you, and this is the debate that we were having, was I say, yeah, but I sometimes feel like, you know, to use the one size doesn't fit all, you know, I feel like you guys are trying to sell me this very beautiful pair of shoes, you know, but I have size 46 feet, and you're saying, okay, they're size 43, but they're beautiful shoes. I mean, they're very expensive. They're wonderful shoes. I'm saying, yeah, but they don't fit my feet. I have bigger feet. I need a different type of shoe for this. And so when I hear discussions, and I think I'm very pleased to hear about the plans from the ICC to develop more of a virtual platform. But what I'd say, you know, I don't think that offering, and I like the idea also of having different options, of having maybe Teams, Zoom, and maybe even a dedicated platform. But I hope that the ICC and other institutions and arbitrators as well will consider the proportionality of using technology. I'm in my office right now, and we have these wonderful Cisco telepresence rooms that I can use. I mean, we're a big company, and we can afford to do that. A lot of the parties that we have disputes with don't have Cisco telepresence rooms. You know, it's the gold standard really of online video. It's very expensive. If you wanted to do things online, you could say, well, you know, we'll use these very expensive telepresence where it really seems like you're in the same room with the other people with high definition video and high definition quadraphonic stereo effects. You know, and so I do hope that as we get into this technology, again, we won't just say, let's go to the maximum all the time. Let's please apply some degree of proportionality. And I'll tell you why I think this is really important. A lot of companies will not do international arbitration, or they avoid arbitration, especially outside of the United States and the common law countries where arbitration and court litigation are kind of more or less the same cost. But in a lot of countries, arbitration is actually a lot more expensive. And so it's very difficult to convince the other side sometimes to include arbitration in the contracts. I actually think that this is an opportunity to reduce the cost, to actually make arbitration more accessible to, you know, to parties who are involved in smaller disputes, you know, those $300,000, the $500,000 disputes that today, you know, I mean, a lot of parties, if you're in France or you're in Italy or another country, would say, you know, I'd rather do those in the courts because I'm not going to have to pay so much money that I would have to spend if I go into arbitration. You know, my one little 2 cents to say, proportionality, folks, please be proportionate when we're looking at these technologies.
We are quickly running out of time, so I would like to move to written pleadings, which of course are much less affected than oral pleadings for obvious reasons. And one thing that occurred to me is that this might, in a way, shift the parties' reliance on written advocacy from oral advocacy. And please believe me, this is not the wish of a civil law lawyer, but I would like to hear, for example, Andrew, what do you think about this?
Sure. So my perspective is that as compared to U.S. litigation or domestic arbitration, where there's such a focus on oral, not only oral advocacy, but oral testimony and the oral submission of evidence, you generally have depositions and live, direct, and cross-examination. I tend to find that in the international arbitration practice, there already is sort of a heavy, I don't know if premium is the right word, but a heavy emphasis on written submissions, not only the advocacy, but also the evidence. But I do think that one way that the written submissions can become more effective, and I think this goes back to something Mike was saying earlier, and this is a thought I had independently, is to have intermittent comments and questions from the tribunals on the written submissions as they're receiving them, especially in the case of simultaneous submissions where you tend to have parties talking past one another and then everyone shows up at a hearing and continues to talk past one another. I think in terms of how the new sort of virtual platforms can help hone and make the written submissions more effective is that after each round of submissions, I think the virtual platform makes it efficient and cost effective for the tribunal to hold in essence a mini hearing, to look at what the parties have submitted and to submit some questions, ask counsel to prepare to ask particular questions based on what the tribunal is looking at in the submissions, and have a hearing and focus things going forward so that you're sort of funneling everything towards what the tribunal feels, obviously with the guidance and based on the urging of the parties, feels is the most important. I think oftentimes you have this issue where there's 20 issues in the case, but really only 2 matter, and equal time is given to both in the written submissions and at the hearings. And I think the opportunity for more communication, whether it's written or oral or both, to narrow and focus the disputes, I think just makes for a better process. So I'm not sure if that totally answers the question, but I do think that the virtual platforms provide more opportunity to enhance the efficacy of the written submissions. But I do think the written submissions have always taken primacy in international practice, and I think they'll continue to, especially since most evidence, at least in the first instance, is submitted in writing.
Not sure many lawyers I know on this side of the pond would agree with that statement when they're dragged into several weeks long hearings, but I take the point. Mike, Ziva, any comments on this?
Mike might be frozen.
Yeah, and I think
no comments for me. I agree with what Andrew says. By the way, it wasn't my idea, Andrew. You and Mohammed Abdul Wahab seem to, I'd say, great minds. No, but I think this is actually a moment where this shows that people are thinking about what are the opportunities to do things better that this moment provides. And I'll put my hand on flame, as they say in Italian. That I think if you had that tribunals, if arbitrators were engaging with the parties more often, we would feel that we were getting more of our money's worth, right? We would see what were going on. The process to us could potentially be more predictable. But the downside to that, well, downside, it's the upside to me, is that the arbitrators would actually have to read the submissions as things are going along, rather than, and I think this is a common problem in arbitration, is that they don't do the work until they get to the hearing, and if they're good, they prepare so they have questions at the hearing, not at the end of the, throughout the hearing, not at the end of the hearing.
And
but I think you would find that people would be much more. I think you'd find parties like me would be have a much higher rate of satisfaction to go with your and Mohammed's idea.
The arbitrators already have to read the submissions if you want to have a midstream conference. It's the same. I think that if you have some intermediate steps where everybody sits down and discusses, and it could also be a small hearing on a particular issue, right? If the technology of all involved is allowing it, and that's not disproportionate. There are so many things you can do to increase the involvement of the tribunal throughout the proceedings.
Ziva, it also, I think, wouldn't it give the arbitrators a right to earn their fees, right? Because right now, under many rules, arbitrators may not see their fees if things are being postponed, if nothing is happening. But I think that they'd have to do the work. They could bill for it, and I would think the parties would be comfortable paying that on an interim basis, rather than waiting for things to conclude.
Oh yeah, and that is actually, it's another lesson that we learned from this. In the note somewhere it says that the court will also consider the circumstances in assessing the requests for advances on fees. And I think that the court has been quite flexible in seeing, okay, this work has been done, the tribunals can get paid, and everybody appreciates that, including the parties, I think, in these times. And yeah, it's a good encouragement to get your hands on the case, although you can't travel all to the same place.
In a few minutes left, there is one perhaps last topic I would like to touch upon. We've been talking about real arbitrations made of hearings and submissions, but we all know that there is a parallel international arbitration world, or rather a world surrounding the real international arbitration, which is made of conferences, trainings, programs, all sorts of things, which is what we are doing today is actually very much part of. This has been, and we I think continue to be for quite some time, even more prohibited than hearings, because it's of course even larger gatherings of people. And in the meantime, in the last couple of months, we've seen a lot of alternative types of trainings and programs, again, such as the one we are having today, which is virtual. And I think what has changed is not only the tools and the means we are using, but it necessarily has an impact also on the content. And so I think it also means more specific and more focused, more targeted, and sometimes more tailor-made programs. And so I'm wondering whether this could also be something that will that is here to stay at least more, or whether we are just can't wait to go back to conference cocktails. And so if it's here to stay, I'm also wondering precisely whether this is such a bad thing. Mike, what do you think?
Well, I think it's been terrific. Well, I speak from the point of view of in-house counsel, where we don't have budgets to travel to conferences, let alone money with that our general counsels will pay us, or their CEOs want us to pay for the admission fees. I think it's been a moment where there's been a tremendous, number one, there's been a tremendous amount of great content moved online, and not just in arbitration, but practically everywhere. If you look around, no matter what your hobby is, whether it's playing a musical instrument or photography, people who were not doing online trainings before, they were charging a lot of money to do things in person, have moved content online. There's just great stuff now that you can do. And I think that's true also with arbitration. It's also allowed these forums to take place internationally like this. One thing, and I'm going to look, I don't see if I can see through. There's still people there. I can see that, but there's no questions. I mean, it's nice to see when there are questions. I can see there's somebody typing. Yeah, they submit your questions, and this can actually be more interactive than when you're at a conference where you're sitting on a stage and you're talking and you don't see. You don't have that interaction, or you'll have one person from the audience who will say, it's my favorite saying is there's no such thing as a question from the audience at an arbitration conference, because typically that one question is a mini speech that will often last longer than the panel that preceded the question. So no, I think I hope this continues. I've heard, by the way, I've heard great feedback from a number of my colleagues, and I hear now people saying, I heard on this webinar, and somebody said on this other, and things are getting around. You hear what people are saying on these webinars. Oops, we should be careful what we said today.
Talking about questions, Florence, I'm sorry, yes, I was just wondering whether we had some.
Yes, we have some. The first, there are two questions. Sorry, one is in line with your discussion. Sorry. What are your thoughts about the Seoul Protocol on video conference in international arbitration? Do you have any views on that protocol?
To be candid, I've reviewed it. Not in the last few days. I think it's somewhat comprehensive and is a step in the right direction. I don't have any specific comments as to what its deficiencies or real benefits are, but I certainly think the notion of having those types of protocols are important, and I think maybe a more universal protocol, a more universal protocol that might be applicable before various institutions could be helpful in terms of setting parties' expectations for virtual hearings.
All right, and a question for Andrea. Is it better to stay online or in physical contact with colleagues and judges and clients in the future?
This is for me?
Yes, specifically for you.
I think it depends on who these colleagues and judges and people are. I think this is a very philosophical question. So I think we are all, I mean, whatever, all we are saying is precisely that I think that there is something to be learned, and it will be good to learn from this experience. But I think we are all also missing the human side of our profession, and I tend to think that this is what we miss most, more than precisely the opportunity of cross-examining a witness or other aspect of arbitration proceedings as we know it.
And that's true also for UIA, where the physical links and the networking, and in many other organizations, networking are very much important. Also in other fields than in the field of arbitration. what types of arbitration have been resolved from the beginning of COVID pandemic? Either mostly commercial or investment arbitration? I think there is we don't have any figures on that. Your impression? I'm not sure that I think that things are ongoing, either commercial or investment. The idea would be whether further commercial arbitration or investment arbitration started during this period. That would be another question, but I think we don't have the figures. Do you have any idea on that?
I think Ziva may have figures for the ICC, but I can tell you that the arbitrations, we've had a number of arbitrations that have started during the pandemic, and I think in all of them, there's been some discussion, how do you keep the forward progress going? And I don't think, with one exception, where it wasn't a question of scheduling a hearing, it was more of a question as we had people in difficult places to reach and documents moving around, where we felt that it was necessary to ask for a short extension just to provide our statement of our main submission, but it wasn't a substantial delay. I think I don't work in the area of investment arbitration, only in commercial arbitration. I think for the most part we haven't seen any delays. If anything, I've actually seen proceedings seem to be moving more quickly, and maybe it's because people have more time. It's easier to schedule. You're not planning to block time. You know, if you have 2 days of hearing, you just block the 2 days of hearing. I have to say things seem to be moving along pretty smoothly, at least from my perspective. I'm curious what everybody else sees.
I think it's difficult to draw conclusions precisely to have figures, but I think it's also interesting that as on previous occasions of major international crisis, I'm thinking of, I don't know, the Arab Spring, there are specific disputes that were caused by certain events. So I think both in the commercial fields, and we know that, for example, there are many disputes or claims based on or defenses based on force majeure for failure or delayed performance. On the other side, we can think of claims, investment claims based on measures taken by states.
Thank you. Oh, sorry, Ziva, please.
I think that I think it's a bit early for those investment claims that I think they are going to start coming through, but probably they need a bit more time to be fully formulated. And I think that in ICC cases, we have seen very few cases where on the merits the claims arose out of the crisis. A few instances where they said that the breach was aggravated because, you know, delays in the supply chains and stuff like that. But otherwise, so we are yet to see the disputes where breaches are created, you know, like where like damages are claimed on the basis of the lockdowns in different countries, right? On the other hand, I completely can confirm what Mike has said. I think that we have received more requests than this same, at least in April, than last year. We have received a lot more awards because I think that it's easier now for many arbitrators because of all these cancelled hearings to actually finalize the award. And we have not seen any slowdown. And yes, there have been quite a few extensions, but I think that all in all, it kind of probably evens out. Yeah.
And following Andrea's reference to force majeure, there is a question about force majeure and investment arbitration. Do you think that this pandemic will create a flow of force majeure proceedings and a possible crisis as the Argentina one?
Well, I don't know. As I said before, I think it's likely that we'll see both types of disputes. In what proportion and to what extent is, I think, difficult to say now.
I guess I have to question why that question is focused on investment arbitration. I would think that the force majeure disputes are going to be very big in the commercial space. And you know, as a party, you're put in a difficult situation. Do you notify the force majeure and expose yourself to a risk of termination of the contracts? And I think we're going to see a lot of disputes arise from, you know, was this a true force majeure event? Was this an excuse to terminate? Because capital, you know, the liquidity right now is contracting. And I think everybody's trying to do what they can to maximize their cash flows right now. So I think I'm seeing, you know, disputes arising in the commercial space because of the force majeure event, which it is.
All right, and at the end of the question, I think we are on time. It's thank you to all of you, and to the participants for attending our webinar, and hope to see you in another different time other than pandemic time. Thank you very much. Bye-bye.
Thank you very much.
Everybody. Thank you.
Bye-bye.